Can I sell my home in a Chapter 13 bankruptcy, and what are the steps? This is a long video, longer than I want it to be, so I'll give you the short answer, then you can listen to the rest if you want to hear about it. Yes, if you're in a Chapter 13 bankruptcy, you can sell your home, but you need court approval. After you get that offer and you accept it, it's still 30 to 45 days before you can sell the home. That's how long it takes to get the court approval. It's a complicated process. Okay, now let's back up and actually discuss what's involved. On the day you file bankruptcy, everything you own becomes an asset of the bankruptcy estate. Your home is part of the bankruptcy estate. The bankruptcy trustee administers your estate for the benefit of your creditors to make sure everyone gets paid fairly. If you want to refinance that home or sell that home, you need court approval to do it, and you need trustee approval. This can be a complicated process. I've divided into 6 steps to try to make the process a little more simple, but it's obnoxious. Okay, step number 1, let your attorney know before you make the list. Otherwise, you might be making a huge mistake. Step number 2, have your realtor talk to your attorney right away. Now, your realtor is going to call your attorney. They're commission-based, and sometimes they're a little bit pushy. No, really, they are. They'll want to talk to your attorney and know what's going on. Step 3, let your buyers, all of your buyers, well, maybe not all of them, at least the really strong potential buyers, let them know that it's going to take 30 to 45 days after that offer to get court approval. It is a slow, painful process. Step 4, when you accept the offer, send it to your attorney right away. Don't delay on this one, because when your attorney files the motion, that's when that time period starts. Number 5, your attorney has to file a motion to approve sale of real property, application to employ realtor, and request for fees. It's a lot of motion work. And step 6, 25 days-ish after you file the motion, hopefully your sale gets approved. Now, let's go into the steps in more depth. Number 1, let your attorney know first. Let your attorney know because you might be making a huge mistake. You might have too much excess equity in your home at this point. Back when you filed the bankruptcy, you listed the value of your home, and you probably lowballed the value to show you didn't have any equity to pay your creditors with. Let's say your state exemption let you protect $50,000 of equity, so you applied a $50,000 exemption. Now, 2 years later, you want to sell the home and there's 200 grand of equity. You're thinking that would be great to keep the whole 200 grand. It would be great, but it's probably not going to happen. The bankruptcy trustees are very successful in arguing that you get to keep that $50,000 exemption you originally claimed, but all that excess goes to pay your creditors a little bit more. It may not sound fair, but that doesn't matter. That's how it is. Bankruptcy trustees are good at that argument. So talk to your attorney before you start making hopes and promises for something that may not actually happen. And let your attorney know right away so he can start billing you for his time. Selling your home is not part of a regular Chapter 13. Your attorney will be billing you for the work he does, and you'll have to pay that above and beyond your regular attorney's fees. Step 2, have your realtor speak to your attorney. Attorneys hate this. I don't like talking to realtors. I'm pretty sure realtors don't like talking to attorneys, but we need to get it done. The attorney needs to file an affidavit of disinterestedness on behalf of your realtor to show that the realtor isn't a close friend or family member, some kind of insider. And if they are an insider, the court will probably not approve their realtor's fees. Realtors hate finding this out, and it's really bad when you try to throw your sister realtor a bone, letting her sell the home, and then she doesn't get any money for her efforts. Step 3, let your buyers know it's going to take 30 to 45 days after the motion is filed before you get court approval. Now, your realtor may have heard at a conference 3 years ago in Michigan an anecdotal story that yes, you can get this approved more quickly with an emergency motion. I've heard the same thing, and it might be true, but it's really difficult, it probably doesn't apply to you, and it will require a lot more attorney's fees to get it done. So let the buyers know, 30 to 45 days minimum. Number 4, when you accept the offer, send it to your attorney immediately. That time period runs from the time your attorney has time to draft and file the motion, not from the time you accept the offer. So get him the paperwork. As for the paperwork, he's going to need the offer, the acceptance, the listing agreement for the realtor, a mortgage payoff statement, any other mortgage documents you have. Anything you think is relevant, get it to your attorney. Step 5, your attorney gets to file a motion to approve sale of real property. needs to get the realtor's fees approved, and needs to file an application for his own fees. Attorneys generate a lot of paper. I imagine that the really faithful attorneys for the Sierra Club cry every time they have to draft a new memorandum and wipe out a small forest of trees. Bankruptcy is no different. We generate a lot of paper, and all of that paper needs to be filed with the court. You'll need court approval, you'll need trustee approval. This goes out to every one of your creditors. Every one of them could object if they find something isn't fair in the deal. Your realtor needs to be approved. The fees and commissions need to be approved. Closing costs need to be approved. Most importantly, the attorney's fees need to get approved for the attorney. There's a lot of work, and your attorney will bill. Now, on a really, really simple motion, you might only pay $750 for the motion. That $750 may come out of the closing costs. It may come from your ongoing Chapter 13 plan payments, but it's probably going to be more. Plan on it. Your attorney does not work for free, and it is complicated and obnoxious work. Step 6, 25 days-ish after filing the motion, you will get court approval. But it could get complicated. There may be 2 hearings. You may have creditor objections. Even after the court seems to approve your motion, it may take the judge another week to sign the order. There are delays. Some of the delays are built in, some of them are a surprise. Plan on it and let your buyer know. Now, that being said, you can sell your home in a Chapter 13. It just takes some effort. Now, if you're selling the home, realizing equity and paying your creditors off in full, I don't think anyone else is going to object. But still, it takes a lot of effort, so good luck.